Okay. So, I mean, I can confirm to you that Fairstone still have not transferred the debt to anyone, and they do maintain ownership of it.
If you don't mind me asking really quickly, Ellen, what steps exactly did you take to verify that Fairstone still maintains ownership of the debt? Because you're stating that, you can confirm that they own it, they haven't transferred the rights. I'm just curious as to what method you used to verify that information.
So, Colton, I'm not sure that how much I'm able to discuss this with you. And before I think that we can go any further with this conversation, I'm gonna need to talk to my client about this and get some instructions from them as to what kind of information that I'm able to provide Mr. Marinik.
You just said you're confident they own it. So, we're just wondering why you would make that statement if you haven't received any documentation at this point. Because, now you're saying that you have to go ask Fairstone what they can give you, but I was under the impression by your statement that you had already received some sort of verification.
Well, I'm going to need to talk to my client before I continue this conversation any further.
So that was Ellen Fitzgerald, okay? She's a Fairstone lawyer, and that was regarding a mortgage in Saskatchewan. And, well, you can see based on our line of questioning there, she got very nervous and she actually couldn't answer our question. At the beginning, she said, yeah, we own it, I can assure you. When we asked her, well, how do you know? What did you do? Because obviously we're about to forward you a lot of money. So, what steps did you take? And she freezes up. I can't discuss this with you, blah, 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 blah. So we figure, okay, whatever, we got her cornered. She can't prove that they own it. So we figure that when we ask the same line of questioning in a court of law, who has strict requirements for proof. Our entire judicial system is based off of evidence. You got to be able to prove shit. You got to be able to prove your fucking claims. That the judge would be in full support. Well, yeah. How did you verify that they owned it? The judge should ask. Okay. Well, Ellen, do you have any paperwork that you can put forth to prove that Fairstone maintains the ownership rights? And we'll show you what happened in court.
So here we've got the only filing made by Ellen Fitzgerald within this case. And it's just an affidavit from the director of centralized collections who's employed by Fairstone. So this is already kind of showing a conflict of interest. And this is specifically why we request an affidavit from a chartered accountant, because a chartered accountant is governed by a third party, CPA, chartered professional accountants. And what this does is it ensures that all the information that they report is accurate, because they are not employed by the entity who's under scrutiny. They're employed by a third party, meaning that if they make any inaccurate reports, they lose their license. And this is what prevents chartered accountants from being in a conflict of interest when making such inspections. But anyways, so this affidavit is what Fairstone is relying on as evidence, okay? And it reads, I'm the director of centralized collections employed by the respondent. I have such knowledge of the facts herein disposed to. 2, the mortgage filed with this application has not been transferred or assumed. Okay, again, that's mere hearsay. That's just an assertion with no documentation to substantiate that claim. Number 3, the claim of the respondent is under a mortgage made by borrower's name in favor of Fairstone Financial Inc. dated November 29th, 2019, and registered in the Information Services Corporation December 9th, 2019 as an interest registered number, is the mortgage number, against title described as follows. Attached here to and marked as Exhibit A is my affidavit is a copy of the results of the current search and land titles registry. Now, I'm going to show you guys the borrower's responding affidavit where he really addresses this further. But at the end of the day, land titles does not keep track of all the internal transactions that happen at Fairstone. Okay, every time Fairstone sells a contract or securitizes a contract, it doesn't report that transaction to land titles. All right. So just because a security was registered at land titles 4 years ago does not mean that in the last 4 years, the contract that security, that land titles registration is based on has not been sold to a third-party investor. Okay, so land titles does not keep track of all the internal transactions at Fairstone. So to rely on a land titles registry made in 2019, it's now 2025, is not proof of ownership of the rights to that contract. That just proves that you guys registered in land titles 6 years ago, right? So relying on that is a little bit ridiculous. And I mean, you could put all these questions to rest if you would just have a chartered accountant inspect the company's ledgers and confirm that they currently maintain the ownership rights. So I'm not sure why we're doing this dance around. We'll provide anything to you except for that, because that would be the most reliable source of evidence. And that is a prerequisite for evidence when you go into court. Obviously, you want to use the most reliable means available to you. One of which is not a land titles registration to prove beneficial ownership rights of a contract that land titles does not keep track of. 5, attached here to and marked as Exhibit B is a true copy of the mortgage. So they just took a copy of the mortgage agreement. Again, this is not proof of ownership. If they were to have sold the mortgage, they would retain a copy of the mortgage agreement. So just because they still have a copy of the original agreement on file, doesn't mean that they still maintain the ownership rights. The same way, if I sell a car and I have a photocopy of my registration from 6 years prior, that doesn't mean that I still maintain the ownership rights to that vehicle because I just have a photocopy of my old ownership information. I could have sold it at any point within the 6 years and still had that photocopy with me. So to use that as undeniable proof that we maintain ownership is a little bit ridiculous. So now this is the borrower's responding affidavit in which he addresses all of those concerns. Obviously, I didn't include the entire affidavit just to redact some of his personal information. So we'll start at Part 9, which is the most pertinent. The original mortgage agreement I entered into contains assignment clauses that expressly permit Fairstone to assign, transfer, or sell the debt without my knowledge or consent. And that's fine. No one's debating that Fairstone isn't allowed to sell the debt. It's just that if they are going to sell the debt, or they're going to have the ability to sell the debt, well, then before they collect funds, that they should have to prove that they haven't done so. Number 10, given this contractual provision and standard industry practices, the critical question is not whether I signed the original agreement, which is undisputed, but whether Fairstone has exercised its assignment rights and transferred ownership to third parties. And that's a fair question. The Can affidavit, which is the one that we just reviewed, provides no evidence that she examined corporate ledgers showing current asset ownership, transaction records documenting any assignments or sales, securitization documentation, or internal accounting records confirming current ownership status. So he's just calling out the lack of substance to her affidavit. It's just further hearsay and assertions without any of the requested documentation to prove the legitimacy of those claims. Number 12, Mrs. Can's statement lacks specificity regarding what records were reviewed and when, whether she has access to all corporate transaction records, the specific dates as of which ownership was verified, and whether she consulted with other departments involved in asset transactions. So again, her affidavit is very vague. She's not specific about what she did to confirm ownership. All she did was pull land titles. She didn't review any documentation. She doesn't specify exactly what date she confirmed that the debt was still owned, and she didn't consult with any other departments. I mean, it's a little ridiculous. Number 13, for Fairstone to establish legal standing to enforce this mortgage, I respectfully submit that proper verification should include a sworn affidavit from a chartered accountant who has independently examined Fairstone's internal ledgers and can verify current ownership of the debt. B, documentary evidence of the complete chain of title if any assignments or transfers have occurred. C, verification that no securitization activities have affected ownership of the specific debt. And D, internal corporate records confirming current ownership status. And all of which he has been requesting for quite some time with quite a bit of resistance from Fairstone as you remember from our conversation with Ellen. 14. The current affidavit fails to address the fundamental question: does Fairstone currently own the debt that justifies enforcement of the security interest? Land titles, registry evidence, and employee statements cannot answer this question. 15. Without proper verification of current debt ownership through examination of internal corporate records by qualified professionals, Fairstone cannot establish the legal standing necessary to proceed with enforcement activities. All of which I believe are more than fair points here. Fairstone cannot address the lack of documentation, and to just throw some internal collections lady to say that, yeah, we own it. Well, obviously the internal collections is going to say that they own it because they're internal collections and they just want to collect the money. I don't know if any of you are familiar with dealing with collections agents, but they'll say anything to collect a payment, right? Especially when their job is dependent on it. We can't expect a true, unbiased statement from this lady who's employed by Fairstone to collect money from people. So if she were to tell the truth in her affidavit, well, I don't have access to the internal accounting records. I only have access to collections files, and I can't see for sure whether or not the debt has been securitized. She runs the risk of losing her job, which means she is in a conflict of interest because she wants to say anything in her employer's interest so that she can keep her job and look up to her boss. And this is exactly why the verification should come independently from a third party, such as a chartered accountant. And the amount of resistance that we are receiving on that request is telling in itself. So now here is the 3-paragraph analysis of the decision from the acting judge Norbeck on this case, where he says the court engaged the borrower and queried about the relief sought, noting that the application requests the same relief as a statement of claim because the borrower put in an application to compel disclosure of the information that had been requested. The court queried the borrower why he would not accept the CAN affidavit and Fairstone's previous representations, which we had just went over, and which the court reviewed his affidavit. So I'm not sure why they continue asking this question. It's been laid out very simply for them. Mrs. Can did not have access to the proper information in order to make that claim. The borrower explained that he did not believe Fairstone, and rightfully so. They haven't provided any substantial documentation to support their claim. And it had to prove it did not sell or assign the mortgage. Well, no, it has to prove it currently maintains the ownership rights. And in a court of law, for a judge to be acting as if it's unreasonable to require proof is a little bit ridiculous. I mean, this is the judicial system, which is based entirely on evidence. So here we can see a little bit of bias from this judge. The court accepts the CAN evidence as uncontroverted evidence before the court that the mortgage was not assigned. Now, by definition, this is inaccurate because the borrower is disputing the claims, just completely ignoring and not addressing any of the concerns in the borrower's affidavit regarding the form of proof that they are being provided. The borrower refused to accept this and argued that he is convinced Fairstone sold the mortgage. Rightfully so. They've been refusing to prove that they own it for the last 2 years because it cannot provide original loan agreement. That is not true. It's because they couldn't provide an affidavit from a chartered accountant, which was laid out very explicitly and clear in the affidavit. The court cautioned the borrower that he was imposing barriers where there were none. This is just absolutely ridiculous. I mean, he explained very well what the barriers were and why they are reasonable. And for the judge to just say, yeah, no, too bad, just take the collection agent's word for it, is a little bit, it's biased. It's absolutely biased. I mean, in what other situation other than dealing with a bank would a judge act like requiring proof is such an issue? Requiring verifiable proof is such an issue. The borrower explained that he also required confirmation that Fairstone owned the debt in an affidavit evidence sworn by a chartered accountant. The court explained that it was unable to find anywhere in the mortgage documents or otherwise that this was required. So we're not looking at the mortgage agreement to exert our rights as consumers in Canada, this is just simply the most reliable form of evidence to confirm whether or not Fairstone maintains the ownership rights. And the borrower, as a consumer, has these rights to verify his debt before he makes payments. So essentially what we're seeing here, and just so everybody knows, this is undergoing an appeal for all of the reasons outlined in this video, so that Judge Norbeck is going to have to address these concerns. But it appears as though Norbeck is aiding Fairstone in collecting on debts that they don't own by not requiring them to provide proper proof of ownership documentation from a non-biased, third-party chartered accountant who is not in a conflict of interest. So here you can see Canadian court judges are aiding large financial institutions in collecting on debts that they cannot prove that they own beyond a reasonable doubt. For all the reasons outlined in this video, there are reasonable doubts about Ms. Can's affidavit and her impartiality and unbiased nature due to the fact that she's employed by Fairstone. So of course she's going to swear in her affidavit that they own it and then not provide any verifiable documentation other than land titles, which a land titles registration, which doesn't actually confirm anything because land titles doesn't keep track of securitization or internal transactions at Fairstone in which they sell their assets. It's just a security interest on the property.